Good afternoon. My name is Matthew Hyman. I chair the Federalist Society's International and National Security Law Practice Group, and we are the group that's organized this afternoon's panel. So I want to thank you all for being in attendance, and I also want to thank folks watching us on the live stream for paying attention to what I think will be a very interesting panel. Before I hand it over to our moderator, I just want to let people know if you're interested in the work of the International and National Security Law Practice Group, I can tell you a little bit about it. We do panels like this. We have regular teleforum. We have a symposium or two every year, and we cover the gamut of topics that you would expect given our titles. So whether it's trade, electronic surveillance, law of war, anything in the international or national security law realm, we have experts on our executive committee that really dedicate a lot of time thinking about program in these areas. So if you're interested in today's topic or any of the things I just mentioned, I would love to hear from you. I'm around today, but I'm also on the Federalist Society's website. So if you want to track me down, if you want to get involved, just send me a note and let me know. We'd love to have more folks engaged. And so with that, I'm going to turn it over to our moderator who will introduce the panel. Today's moderator is Eric Kadel. He's a partner at the Sullivan and Cromwell law firm. Eric has a wide-ranging practice that covers everything from OFAC to anti-corruption to trade sanctions, a lot of the topics that the panelists will be discussing today. So the moderator has deep expertise, and our panelists have deep expertise, and so I really thank them for attending. So with that, Eric, the floor is yours.
Thank you very much, Matthew. Can everyone hear okay? The mics, I guess they're working. Thanks for coming today. The formal title of our panel today is National Security Law and Doing Business Abroad. And I'd say that it's a little bit misleading as we sort of thought through what we really wanted to talk about today and convey to you. That title became a little bit too narrow. What we're really talking about, I think it's fair to say, is the intersection between corporations doing business and seeking to obtain profit and grow their companies in the sort of ordinary way that you think about corporations as profit maximizing entities. Think about business opportunities within the context of the overlay of national security responsibilities. And you might think, well, that seems like an easy choice, but as you'll see in the context of the panel's discussion today, it really isn't always that easy. There are a lot of tricky questions that can come up, in particular for businesses that are doing business across borders. So we think we've got a great program for you today, and we really hope you enjoy it. Just a note on process, what we're going to do is we're going to go through our discussion and cover a few different topics through the course of our discussion. At the end, we'll save somewhere in the neighborhood of 15 minutes or so for questions. If you do have a question that comes up, please write it down or remember it, and then you'll see there's 2 microphones in the middle of the room there. Please queue up behind those microphones, and we'll take questions in the order of people's presence in the line. And I'll alternate between the 2 microphones, so don't worry about being stuck behind the wrong one. With that, let me introduce our panelists just very briefly. Obviously, their bios are on the website, and please do take a look at that if you want any more information. But first, 2 down to the right is Tim Keeler. He's an attorney with Mayer Brown in the Government and International Trade Group. Prior to joining Mayer Brown, Professor Keeler, and he is an adjunct professor at the Georgetown University School of Law. He was in a variety of senior positions in the U.S. government, including Chief of Staff in the Office of U.S. Trade Representative from 2006 to 2009, and then at the Treasury Department earlier in his career. At the far end of our panel there, we have Don Rosenberg. He's the Executive Vice President, General Counsel, and Corporate Secretary of Qualcomm Incorporated. Mr. Rosenberg reports directly to the CEO, Steve Mollenkopf, and is a member of the company's executive committee. In his role as the Chief Legal Officer, he's responsible for overseeing Qualcomm's worldwide legal affairs, including litigation, intellectual property, and corporate matters. Qualcomm's government affairs, international audit, and compliance organizations also report to Don. Prior to joining Qualcomm, Don served as the Senior Vice President, General Counsel, and Corporate Secretary of Apple, and before that, Senior Vice President and General Counsel at IBM. Don has also served as an adjunct professor. You'll see this as a theme. He was at New York's Pace University School of Law, and he taught courses in intellectual property and antitrust law. Third, we have Randy Milch. He is between Don and Tim, and he's the co-chair of the NYU Center for Cybersecurity and a professor of practice at NYU School of Law. Before that, and most recently before that, he was the executive vice president and strategic policy advisor to Verizon's chairman and CEO, and served as the company's general counsel from 2008 to 2014. At Verizon, Randy chaired the Verizon Executive Security Council, which was responsible for information security across all Verizon entities, and he was responsible for national security matters at Verizon beginning in 2006. Finally, next to me here, Jim Haynes. He has served in a variety of roles in the government. He was the general counsel of the Department of the Army and later general counsel of the Department of Defense and director of the Defense Legal Services Agency from 2001 to 2008. He's also been in private practice as a partner in the national law firm of Jenner & Block, and he's been in-house in the biotechnology, energy, and national defense industries with a number of major companies, including Chevron, General Dynamics, CSRA Inc., and SIGA Technologies, SIGA. Graduate of Davidson College and Harvard Law School, Jim is an honorary doctor of law from Stetson University and has numerous awards for his public and private service. As far as I can tell, Jim's the only one of us up here not currently or that has been a professor of law. I am an adjunct at GW Law. So with that, let's just launch into what we're here for. And just to set the stage, what we're going to talk about first is an area of law called National Security Review of Foreign Investment, or you might colloquially have heard this referred to as the CFIUS process. And in the United States, the CFIUS process is a means by which foreign investors who come in and obtain control, or as Tim will explain a little bit, in certain sectors, if they just have a minority investment, may need to go to an interagency group chaired by the Treasury Department and obtain a review of that investment for national security reasons. And there's a wide range of options that CFIUS has in evaluating a transaction, including potentially referral to the president. And I'll start with this first question to Tim. So Tim, very recently the Foreign Investment Risk Review Modernization Act, or FIRRMA, was overwhelmingly passed by Congress on a bipartisan basis, following extensive negotiations with the administration, and President Trump signed it into law in August. FIRRMA substantially reforms the CFIUS process as we know it, and FIRRMA was described by a number of legislators, including Senator Cornyn, who was the principal sponsor of the reform initiative, as designed to address both gaps in the pre-FIRRMA CFIUS process and to address serious concerns that China and other foreign countries may be seeking to obtain leading-edge American technology, both established and emerging, and to leapfrog United States' advantage in technology. Can you tell us a little bit about what happened in FIRRMA? What was it all about? How did FIRRMA end up becoming both FIRRMA and the Export Control Reform Act, and how did it change the CFIUS process that we know?
Sure. Again, thanks, Eric. Thanks to the Federalist Society. Thanks to my panelists for being up here. So as Eric started to lay out, a lot of what's driving changes in national security law and policy are really the big shift going on in both at the presidential level and in the national security bureaucracy about its view of China and what to do about China as a potential adversary that is different than what the Soviet Union was. And CFIUS is, in some ways, this bill that passed is Congress's imprint on it. So I'll talk about CFIUS, I'll talk a little bit about export control, and then I'll talk a little bit about some of the national, sort of new and emerging national securities and technology issues that are arising. So CFIUS applies to the acquisition of control of, as CFIUS defines it, of U.S. businesses by foreign persons. That's what's called a covered transaction under CFIUS. And that is pre this recent enactment of a statute changing it. That was the general rule. And they were technically voluntary filings by parties. I say technically because if you were a Chinese investor and you wanted to put in $1 billion buying a U.S. company, and it had any sensitivity at all, which these days pretty much means any company that Chinese really want to invest in has a risk of being considered sensitive by the U.S. government, you would want to get a letter from CFIUS saying that they are okay with this transaction. If you don't, then it's possible the President of the United States could force a divestiture, meaning you have to essentially do a sale, a fire sale, or they could impose terms to change material terms of the deal to take care of national security considerations. So while it was technically voluntary and still many transactions it is still technically voluntary, there's a huge incentive for parties to want to file before they actually cut the check. I'd used air quotes for the word control because CFIUS keeps it deliberately ambiguous. It's different than market definitions of control. You might think of control as 51%. That's not what CFIUS views it as. CFIUS's only bright line has been thus far less than 10% and passive is not control. So anything above 10% and anything non-passive, one board seat, could be considered control. And as I'll get into, that they've even gone farther than that in the new statute. There's been significant scrutiny of China in the past 10 years. This predates Donald Trump. In the Obama administration, there was heavy scrutiny, in fact, blocking and of proposed transactions where Chinese companies would gain control of U.S. semiconductor companies. And then since the Trump administration has come in, Chinese investment has dropped dramatically into the U.S. Chinese CFIUS filings have also dropped dramatically. There's been, I think, a lot of made up for by other foreign investors from pretty much everywhere else in the world. But Chinese investors have definitely been spooked by the Trump administration in the past almost 2 years. CFIUS is also concerned with state control of foreign investments as a general proposition. You may recall over 10 years ago, there was a lot of public outcry about potential takeover of Unocal, an oil company, by Sunak, and also Dubai Ports World attempted takeover of some ports in the United States. So more recent concerns are any U.S. businesses in the tech space, anything companies that hold data, especially personal data, companies that have physical locations that might be near sensitive military assets. A great example is CFIUS actually blocked the acquisition of, I think it's the Hotel del Coronado in San Diego, and if you've ever been there, you can see there's Marine jets flying right in that area that you can see from the hotel, and they blocked that purchase. So really, you can't. 10 years ago I might have said, hey, if you're buying a hot dog stand, it's not that sensitive. But if the hot dog stand is on a military base, in fact, it can be sensitive.
Depends where it is, exactly.
One thing that the Chinese started doing was shifting away from acquisitions and starting to do licensing deals. And licensing deals of technology that wouldn't meet certain export control thresholds. And this really made a lot of the defense agencies nervous because they weren't having to ask, the parties were not having to ask permission from either CFIUS or from export control authorities before they got their hands on this technology and might be able to build it back up on the other side. And they had sufficient concern that, in fact, I think they started talking to Senator Cornyn, and that's why he moved to expand CFIUS jurisdiction, both to cover small investments in the U.S. That weren't passive, less than 10%, non-controlling, and also expand CFIUS jurisdiction to cover essentially outbound movements of technology. That's what the bill would initially do. A lot of U.S. businesses were very concerned with the breadth of that. The final version moved that outbound piece to a new export control process. So, for the most part, the bill has been enacted but not fully implemented. It expands CFIUS jurisdiction to, as I mentioned, small, non-passive investments. For example, you could have just 5% plus one board seat, and the CFIUS could have, if it's in a sensitive sector, jurisdiction to block that or investigate it at least. It creates a new short-form declaration to sort of make one thing potentially easier for some businesses where they don't have to do a full filing, but they can get CFIUS's blessing and the safe harbor that might go along with that. It mandates that certain parties that have where governments have substantial interest in them, are mandated to file when they're investing in the U.S. Also granted authority to CFIUS to make other transactions mandatory, which they have started to do with a pilot program that actually just went into effect this past weekend. On the export control side, what Congress decided to do was create a new category of export controls called emerging and foundational technologies. They didn't really define it, but I think the general gist of it is they wanted to create a process where the executive branch could move more quickly to control uncontrolled technologies, and through the normal course of action, it might take too long to do so, either unilaterally or through multilateral export controls. I think as we go forward, it's going to be very important to watch not only how the administration implements the new CFIUS rules, and we can talk more later about the pilot program they rolled out, but also when they start to implement these new export controls, how far do they go, what do they do? And I think it'll also be interesting to see how the administration handles, from a broader perspective, some new and emerging issues in the national security and technology space that might arise in, say, government contracting. For instance, Amazon seems to have a pole position for the DoD's new cloud-based classified web service. At the same time, they're providing very similar services in China. And even if one assumes a lot of the IP is protected, does that, having those two customers with very similar programs, does that raise vulnerabilities just by dint of being a customer on both sides of the Pacific that we may not have been concerned about in the past? It's certainly, I think we're going to see a lot more of cases and instances where those types of new issues really raise concerns. So,
great. Thanks very much, Tim. And Don, if I could turn to you next, and I'm sorry if this is bringing back some bad memories from earlier this year, or maybe it's good memories, but in any event, memories. And Tim's laid out for us the sort of jurisdictional framework of what CFIUS is, what CFIUS does, and the process. But you've got some real world experience with CFIUS process, and national security law played a profoundly important role in how Qualcomm does business at home this year, or I guess last year. CFIUS took the extraordinary step of actually blocking a hostile takeover of Qualcomm by Broadcom and calling the proposed transaction a risk to the national security of the United States. Can you tell us a little bit about what elevated this business conflict to the status of a national security threat?
Sure. First, I just want to thank the Federalist Society. They have been extraordinarily supportive of, in particular, property rights, which we at Qualcomm believe very strongly in, and that includes intangible property rights. And that has been going on for years, actually, not just recently. That is the Federalist Society support. So I just wanted to throw in a word there of thanks. Yeah, so the business conflict, and it was this year. I was actually thinking about that. It seems like it was. It
seems like a long time ago.
3 years ago, but it was just this year. And it actually is a good memory, not a bad memory. I got enough bad memories from this year and the last couple of years that this is actually one of the good ones, although extremely interesting, and it was a tough one. So it goes back, let me give you some context. The business conflict, as Eric called it, was the classic hostile takeover, which you don't see much of these days. And it was Broadcom's attempt, and Broadcom's chairman, Hock Tan, to acquire Qualcomm. It was a surprise letter I received in the middle of the night with no prior notification, other than about a year before, Broadcom had approached Qualcomm to see if we were interested in discussing some form of merger or some other form of get-together. But that had been dropped for quite a while with no further discussions and certainly no further interest on our part. So we received the letter. It announced the intention to launch this hostile. It had an offer in it for a price that was above our market price at the time, but not anywhere near, in our view, what the company was worth. There were quite a few other reasons why the company was ultimately not very interested in that deal, but there was, I think, an assumption, since it was a hostile takeover, and since Broadcom had just recently, days before having sent that letter, met with the president in the White House and declared that they were going to redomicile. Some people think they were a Chinese company. They were a Singapore company, and they said they were going to redomicile to the United States. So the assumption on the part of those who were focused on the possibilities of CFIUS was that, well, that shouldn't be a problem now. They're going to be a U.S. domiciliary, so not an issue. I, on the other hand, started to think about a number of questions relating to their hostile takeover, and one of them was I had had some inkling of an understanding that Broadcom had recently been trying to acquire a smaller company called Brocade, and the history of that was that it was examined by the committee, the CFIUS committee, for I think about a year, and I understood very little, but my information was that the committee was going to object to that acquisition, presumably on grounds that CFIUS would be concerned about. And it was only as a result of that White House meeting and some promises that Hock Tan of Broadcom made, including the redomiciling, that the president, in his prerogative, basically said they were going to approve that acquisition. But I had a sense that the CFIUS committee, which Tim can describe, is made up of multiple agencies in the United States, chaired by the Treasury Department. The CFIUS committee, I think, was left with somewhat of a bad taste in its mouth in terms of the Brocade deal. So that was an inkling to me that I might have some interest there. I also did some research on CFIUS. I had not focused on it as much as I've since focused on it. And it occurred to me that there might be a view that with a hostile takeover, normally what happens is the companies are merging, or there's an acquisition that's ultimately agreed to, and the two companies basically notify the committee so that it can get the approval that Tim was talking about before. But this was a hostile, and we were clearly not going to go in jointly. And it appeared to me that Broadcom had no intention of raising the issue because they thought they had satisfied the requirements by saying they're going to redomicile. But after looking into it, I decided that there is a chance that we could be viewed as a covered transaction here. And even if this deal was to go through, whether we accepted it or whether they successfully completed the hostile, it was important to our company and to the shareholders to know whether there was going to be a CFIUS issue here. So we engaged with the committee on I guess, an informal basis to ask some questions and to raise some concerns. And we found that, indeed, the CFIUS committee was, in fact, interested in this, although it was a kind of sui generis problem for them. And it was one of the issues that actually lasted right through the very end of the process, which was Well, Tim mentioned control, and there's a different control definition here. But a lot of people were saying, well, let's see, suppose, now, Broadcom had put up a slate of directors. So going forward, they wanted to have their slate accepted when we decided we weren't going to accept their hostile takeover, and they wanted to be victorious at our proxy meeting and get their slate of directors in. Presumably, that slate of directors would be more willing to do the hostile. In fact, Broadcom had selected each one of these directors, as well as paid each one of them $100,000 apiece. But still, the notion was, well, these directors will have fiduciary obligations. They can't just simply vote the way Broadcom wants them to vote. And my answer to that was, I suppose that's possible, but they were hand-selected. They were each paid $100,000. And they have been inundated with everything we've been inundated with in terms of the benefits that Broadcom said would be reaped as a result of this transaction. But the CFIUS committee was wondering, well, will they actually have control if they were to win the proxy contest? Because remember, they would just be new directors. It wouldn't be CFIUS. They wouldn't work for CFIUS. So that was one of the hurdles we had to get over. And of course, when I say we, I just was, and my team was trying to educate them on, and they were asking a lot of good questions, and we were giving them all the right answers, I think. I've tried to cull this down because it was a 3 or 4 month story. As anyone who's been through a hostile knows, the process that ensued after that hostile was revealed to us was, to put it mildly, all-consuming. You have to deal with shareholders, particularly institutionals and index funds. You have to be concerned about ISS and Glass Lewis, because what you're trying to do is preserve your company as you think it ought to be preserved versus giving it away to the hostile. So we were faced with, in a short term, a very difficult and taxing question. And of course, the main thing that our shareholders were interested in, at least in the short term, was the fact that the market cap would increase, presumably dramatically, if the hostile was accepted. They even at one point raised their price when we rejected their first bid, and so raised it even higher, which of course attracted even more interest on the part of our shareholders. We were, of course, interested not just in short term, but in the long term. And Hock Tan had made it very clear, and he had a history of acquiring other companies and selling to private equity interests and basically getting some short-term return. And he had made it clear that he was going to reduce fairly dramatically our investment in research and development. Now, Qualcomm spends over 20% of its revenue every year on research and development. For those of you who are aware of what companies generally spend, that's an enormous percentage of revenue. Companies like Apple spend something in the range of 3 to 4% of their revenue per year on research and development. And our research and development is closer to pure than a lot of other companies. 70% of our employees are still engineers. And we started as a research company, and a company that really wanted to develop system-wide mobile communications technology. We're known now for the chips we sell. We started with modems, the connectivity chips, and now we sell a complete application processor along with integrated connectivity technology. And of course, our second business is licensing. The R&D that we spend is part of what we think of as a virtuous cycle. We invest in inventing technology, we protect it with patents. We then license those patents, having contributed our technology to the standards bodies which control the mobile communications industry. And we agree, when we contribute that technology, to license our patents on what are called fair, reasonable, and non-discriminatory terms. That research and development is basically funded by the royalties that we collect from that virtuous cycle I just described. So it was clear that if the research and development was going to be dramatically limited, we were going to have to dramatically, or Broadcom would have to dramatically decrease its investment in research and development going forward. Cutting a lot of pieces out of here, eventually the committee, CFIUS, issued what was an interim order along with what's called a Rawls letter to us. And I brought them with me because I just want to give you some sense of this. So the Rawls letter talks about having sought review of this Broadcom solicitation of proxies. The Department of the Treasury broadened the scope that it originally thought it was going to look at to review the proposed hostile takeover of Qualcomm, the entire hostile takeover. They said, they concluded that it could very well pose a risk to the national security of the United States. Now, what they do when they examine one of these proposals is they go through a process of looking at each party and determining what impact, if any, from a national security perspective in particular, the transaction might have on the United States. They said that CFIUS had identified potential national security concerns that warrant a full investigation of the transaction, and the articulation of the potential national security concerns in significant part is classified. They then talked about how Qualcomm is a leader in technology and standard setting. They talked about the risks that would be posed to the United States national security if Qualcomm's ability to invest in technological leadership was in any way limited. There was a lot of focus on 5G. Those of you who were in one of the last sessions with Ajit Pai talked a lot about 5G and its implementation. We Qualcomm are at the forefront of inventing what will be the technology of 5G. We've been doing it for close to a decade now. 5G is a continuation of 4G, which was a continuation of 3G. There are new and great things associated with it, but there's a lot of investment that goes into reaching that. And it was clear that the committee was very concerned about what was coming in the form of 5G and whether the U.S. was going to maintain leadership in the standard setting process in mobile communications, as opposed to, and they said specifically, the weakening of Qualcomm's position would leave an opening for China to expand its influence on the 5G standard setting process. A shift to Chinese dominance in 5G would have substantial negative national security consequences for the United States.
And that was actually in the Rawls letter that the committee provided.
Yeah. And I'm taking this opportunity because I'm kind of doing a little bit of a sales pitch for the importance of Qualcomm and the importance of Qualcomm's investment in technology. They then focused on Broadcom, and in particular Hock Tan's statements, numerous statements to the press, and they all related to, one way or the other, the reduction of research and development investment and the need for short-term improvement of the stock price. And I'll read one more paragraph from this letter, which I think is important. U.S. national security also benefits from Qualcomm's capabilities as a supplier of products. For example, Department of Defense national security programs rely on continued access to Qualcomm products. Qualcomm holds a facilities security clearance and performs on a range of contracts for United States government customers with national security responsibilities. Qualcomm currently holds active sole source classified prime contracts with DoD. Additionally, Qualcomm currently holds unclassified prime contracts with DoD. Qualcomm's partnership with the United States government encompasses efforts to address cybersecurity and the next generation of wireless, 5G, and the Internet of Things. Limitation or cessation of supply of Qualcomm products or services to the U.S. government could have a detrimental impact on national security. So having made it clear, and the order is as clear, if not more clear, that accompanied the Rawls letter, that Qualcomm was not only important to national security, but was a trusted a partner to the U.S. government, and they referenced both classified and non-classified activities. They decided that they would have to at least try to slow down the process. And in an extraordinary step, extraordinary for those of us who spend time in corporate governance and thinking about proxy battles, they issued this order, which accompanied the Rawls letter. And we were ordered that we could not accept Broadcom's proposed merger, at least in the interim while the review was going on, and that Broadcom shall provide CFIUS with 5 days business notice before taking any action toward redomiciliation in the United States while this order is in effect. And just as a side note, I'll tell you, so I was laser focused on everything going on and everything they were doing. And one of the things I did was the steps they had to take, I determined, to redomicile involved both court action in Singapore and then ultimate action with the SEC here in the United States. So one of the things I wanted to do was follow what was going on in Singapore, and so we retained a Singapore law firm to watch the dockets. And it was clear to me that after, I think it was like 2 months since the declaration had been made that they were going to redomicile, they had not taken one step to redomicile. Now, that didn't say they weren't going to, but it was a helpful fact for us to take a look at. And it also helped in terms of what I said to the committee is, if in fact their slate is voted in our March meeting, and they still haven't successfully redomiciled, now you've got a situation where you do have a foreign entity, if you accept the notion that they then gain control, and control, as Tim said, is a looser standard than we're all used to. Then now you've got a foreign entity, not a U.S. entity that is acquiring Qualcomm. So that was, I think, of great interest to the CFIUS crowd as well. Now, Broadcom made a very belated attempt to speed up their redomiciling, but it was too late because, among other things, the CFIUS committee concluded that they had violated this interim order. And all of this actually took place within a week, or about a week. Less than a week after this order was issued, we ultimately got our final order from the president, signed by the president, prohibiting permanently the merger of the two companies. Now, there's a lot more to it, obviously, and there's questions you should have in your mind of what specifically was it that they were concerned about vis-a-vis us, vis-a-vis Broadcom. That I won't get into, but that's how a business conflict became a very interesting matter of national security and CFIUS issue.
Yeah, thanks very much, Don. And that was really an interesting explanation of the process that we all saw unfold in the news. I know that you have something you want to say about sort of the other direction of the coin, but if you don't mind, right now I'd like to sort of switch gears, change direction away from the national security concerns associated with foreign investment or outbound investment and tack towards a different angle to the national security questions that we're addressing today. And I'm going to address these questions to Randy. Randy, in many cases, U.S. corporations may be called upon to assist governments in criminal investigations or intelligence operations, and this can take various forms, including requests to provide information in the corporation's possession or in connection with data protection or the response to data breaches, cybersecurity incidents. Can you tell us a little bit about how these issues can present themselves to corporations and how corporations might respond?
Sure, Eric. Thank you very much. It's a pleasure to be here. The landscape surrounding dealing with government requests for information or assistance, and assistance is its own separate interesting issue, has changed very markedly in the last decade. And some of these things are obvious when you think about them, but hopefully you guys don't spend that much time thinking about them. The reason that it's changed is a fewfold. It used to be, It used to be that the government request for information from companies was concentrated in a few areas, right? The government used to go ask for banking records, financial records. The government used to go to communications companies to get communications records, and the communications companies had landlines, and they eventually had wireless, thanks to Qualcomm and Don. Those were the centerpieces of government activity as a general matter. I think if you looked overwhelmingly at where the requests came, that's what you would find. Obviously, we've had something called the internet for quite a while, but the internet has become a far more pervasive aspect of everyone's life over the last decade, and wireless and landline are now predominantly, I would believe, convenient access points to the internet as opposed to the end-to-end communications network that people are looking at. And the internet, of course, has transformed transactional life. It's transformed our communications life. It's transformed our social life on the nation as a whole. Not my social life, but other people's social lives. And the result of this is a few very important things. It means that the ones and zeros that the government is looking for are now much more widely dispersed than they used to be, right? So the ones and zeros can end up to be in a lot of different places when the government is interested in an intelligence investigation or a criminal law investigation or something that's a little bit of both. And we're looking now at social networks. We're looking now at any company that basically has transactions over a platform and maintains data about the activities of someone who might be of interest in an investigation. And you know, it's no surprise to any of you that this is getting more and more pervasive when you have warrants now for information that might have been passively collected by your Alexa in-home spy. I don't know what else to call. I don't know what else to call that machine that sits in your house and monitors what you say and at times seemingly blurts out words from the devil without bidding, which is why I unplugged my Alexa. This transformed landscape, the landscape that has much more data, much more widely dispersed, much more intimate data, raises a few issues for an in-house counsel, I would think, and for all of us to think about, because we are very much at a stage where the limits of government action and the intersection with private industry, where we have to remember that in the United States, unlike almost everywhere else in the world, 80 to 90% of all the data, all the infrastructure, everything the government's interested in are in private hands, right? This makes the United States somewhat unique in comparison to the rest of the world. So there are a few items that this raises that I would set out for your consideration. First and foremost, I think from the standpoint of a company who may find itself with data that could be of interest, number one, you got to figure out, are you a company with data that might be of interest? Because many companies don't do that. And many companies are startled when they get the first request from the government for data. And the general counsel, who may be a perfectly good startup guy, or maybe someone who came along with a merger or an acquisition, or maybe someone who does IP work or whatever it is, it may be a little shocked at getting that when the warrant or the subpoena or what we call a D order shows up on the door and you have to figure out what to do. So number one, it's worthwhile if you are in the information business, among the very many things that it's worthwhile to do if you're in the information business, including not having so much damn information so you don't get hacked, but we'll put that aside for a second, am I likely to be of interest to the government? If you think you are likely to be of interest to the government or potential interest to the government because you have data that could be of interest in an investigation, you have to take the next step. The next step is, what is my posture going to be when I get a request? We have all seen that there are companies that have decided that public opposition to government requests is good marketing, is good for marketing. We have seen companies who didn't think about this, but all of a sudden find that their employees are up in arms when it comes clear that there's a request for data, and they have to respond belatedly to employee pressure. Because of this. We've seen companies who have seemingly taken steps to make it impossible for themselves to respond to government requests by the way they've implemented certain technologies. So it's important to have a theory about this, is my view, and it's important for that theory to be a theory that the board supports, because you will quickly find yourself, or could quickly find yourself, with a lot of unwanted publicity about this particular question, which is something that is going to get a lot of people upset, and you're not going to make a good decision when everyone's upset about this. You're just not going to make you're going to make a very reactive decision, and that's not the way that you should do that. I think the significant increase in, part of this is the significant increase in the interest across the board of privacy, data subject privacy, the people who are supplying all that data that might be of interest to the government, and what kind of promises companies might make to their customers about the privacy of their data. I would think that any company that is coming up with a reasonably accurate privacy policy would have to say that the privacy of the data is subject to getting processed by the government. But you know, this all comes together in a question of what your posture is going to be.
How might they handle it? So sometimes the government will come with formal process. It's a search warrant or something else, but sometimes there'll be a request to sort of collaborate as I
Well, I was going to get to that. Let me finish up with formal process. I do have that as my last point. I would urge folks to get a lawyer that's up to date on this, because the law is in flux in this area. It's not, you know, we just had a Supreme Court case that came down, the Carpenter case, which made a very interesting exception to what had been pretty well accepted 40 years worth of law on the third-party doctrine, and now there's an exception for anything more than and a very carefully cabined exception for anything more than 7 days of location data from a cell site. Go figure. But these devices have pushed the courts in a lot of ways because of the huge amount of data that are encompassed in them, and the huge amount of data that's available, and the concern that data analysis would permit the government too easily to get far too much information about an individual. And you know, it's a long-standing theory of how we deal with the government looking for information that there should be friction, right? The government shouldn't have it too easy. This is something that the left and the right agree on. They come back to the center on this from very different approaches. But the notion that there should be friction and it shouldn't be too easy is a long-standing concern if you go back and you read the cases. So you need someone who is up to date on this, because the law is constantly changing. And again, this comes back to your posture. Are you going to publicly refuse? Are you going to get into a fight like Apple did with the FBI over the phone, over the county-owned phone in the wake of the San Bernardino terrorist attacks? So this is something that comes up to things. Let me turn to this notion, if I still have time, about this question of assistance. So assistance comes up in a couple of different ways. I'm putting aside for a moment being a government contractor. So if you have a contract with the government, obviously if you've done your work, you've set out the metes and bounds of what your obligations are to the government, and they have expectations for you. Not that wouldn't make you an interesting potential partner, quote unquote, for extra contractual or other assistance. It might, because they know you, and your people have friends who are in the government, particularly if you do classified work. There are going to be some very close relationships, and those are the one route in which these requests come in is from your government contract handlers, somehow your name gets passed around, and people you don't normally deal with all of a sudden are at your door to ask you for assistance. Assistance, by the way, comes in the warrant arena as well. Title III has an assistance provision. The FISA has an assistance provision that tells any company basically that it has to provide a suitable assistance in carrying out a FISA warrant. So you could be asked for assistance even if you've put in place protective measures to protect the privacy of your customers' data. You could be asked for assistance to undo those measures, and that indeed was the crux of the Apple FBI question. It wasn't about encryption per se, but it was about the additional safety requirements that Apple had put in place to slow down and prevent brute force attacks on the data that's in the phone. So let me turn to this question of assistance, because I think it is a naughty corporate decision, assistance. I'm going to be careful to state this in appropriate fashion. The first thing you should remember about assistance from the government is that if it is secret or covert and you believe that, you're an idiot. There is no such thing as a secret, and particularly if it is secret, that makes it all the more likely that it's going to be disclosed. So you can't operate on a theory that any assistance to the government in the course of an investigation, in the course of some covert activity, in the course of some assistance in a covert activity. God forbid that you'd actually agree to do something covert. I think you should be disbarred and kicked out of the company if you actually agreed to put your people in harm's way that way. But there are lots of assistance aspects that you might think are very safe, no one will ever know, not a problem, right? And then you have a Snowden, or you have and for some reason the government allows someone to leave with reams of data. And your name's all over those, and it's a bad hair day all around. So number one, it's not going to stay, if they tell you it's secret, it's not going to stay secret. So anything you agree to do has to be something that you're willing to see on the front page of the New York Times, which is the old rule about everything you do, right? If you don't want your mother to know about it, or if you don't want it to be on the front page of the New York Times, don't do it. So the question really comes to, in the case of something that might be classified, how are you going to brief your board? How are you going to brief your boss? If your boss doesn't have the suitable clearances. Getting a clearance is a pain in the butt, and these days it takes forever. Now you can demand that if they're going to ask you to do something, I want a clearance for this person for this day, and lo and behold, people have that power to do that, but it's significant. And getting a board, or you're going to have a special board committee. Many companies that have lots of classified contracts sometimes have board committees that are cleared so that there could be board oversight of these activities. All in all, I think that from my own view is that when these requests come in, which they do, they have to be very carefully considered. After all, and in the best of circumstances, this is an important thing to do. The government is doing something important and necessary. That's in the best of circumstances. And without having any other data, which you are probably not going to have because there's a real data asymmetry when you're dealing with these issues, you're being told this is the most important thing in the world and lives depend on it, et cetera, et cetera. You're going to have to take this seriously because they could be telling the truth on that. They could also be lying on that, or not lying, they could be exaggerating. I think that's probably a better way of saying it. I wouldn't say that anyone's lying, they're exaggerating. So you have to figure out a method. If this happens, you have to figure out a method. And again, this is one of those things. I don't think this is a very likely scenario for the run-of-the-mill company. I do think it's a potential scenario in an interconnected world. You never know where the potential nexus of a bit of information or a bit of a transaction might cross Company X's portals in a way that they could be of assistance, but not in a way that really gels into one of the standard forms of process that the government could give to provide you with appropriate protections from lawsuit, appropriate protections that the request has been vetted, and appropriate protections that it's been vetted by someone neutral like a judge. Those are all important protections for a company that agrees to do or respond to the government, right? The neutrality of the judge signing off on a warrant or an order is an important set of protections for a company. If it falls outside any of the standard ways that things can happen, that's a much more significant set of risks that you are potentially undertaking for your company.
Great. Yeah, go ahead.
Can I just follow? You
Sure.
talked about-
You want to just go on the mic?
Sorry, Randy, you talked about commands from the government, and you talked about requests from the government. What about when the government comes in and just sort of lays something on the table and walks away?
Yeah, that happens at times. That certainly happens in the cybersecurity realm. That happens in other instances when they think you might be unknowingly dealing with someone you shouldn't be dealing with. You know, it's like any other information bill. You got to take it. You know, you're going to immediately give it a little bit higher priority in the sense that you can't imagine why they would be coming at the door if it wasn't a serious matter. And you know, I don't know about Don, but I certainly got those phone calls. I got those phone calls from generals in the Pentagon at times, you know, reaming me out for putting out RFPs that, God forbid, included Huawei and ZTE, and how could I possibly do that? I think that you know, you have to take it seriously, and you have to deal with that set of information like any other. Of course, you're in a little bit of an awkward position if you are a government contractor, because that tends to that potentially can influence the way you respond to things that are a little bit out of the ordinary from the government, right? You're going to have salespeople, and you're going to have revenue targets, and you're going to have all those other things, and people are going to say, how can you jeopardize that? And that's when you have to be a general counsel and sort of say, no, or this is why we're going to worry about it.
Or ask for a command or
Right.
directive.
Oh, absolutely. If there's a way to ask for, if you're nuts if you don't demand process, if there's a way to get process. You certainly, if there's a potential for process, and you can work with the government if you have the right people in-house or you find the right people outside to very creatively ensure that appropriate process is done, and modifying, they're even willing to modify existing forms of process if the matter is significant enough, or get you something called a 2511 letter, which basically says no process is necessary, but you get the same protections if it's important enough. If that is a potential route, you've got to be sure you do that, because otherwise you're putting your company at even higher risk because there's the absence of something you could have gotten.
Great. Thanks very much. Don, I know this is horribly unfair, but if there's any way to do it, I'd like to ask you to just spend maybe 5 minutes, maybe 10, just talking a little bit about the other side of the coin, I'll call it, which is when Qualcomm's going out doing business abroad and dealing with other jurisdictions, are there situations where Qualcomm can be asked to essentially force or be forced to transfer technology? And if there is there anything that the U.S. can do about it or should be doing about it?
So we've never been asked to transfer technology. We wouldn't if we were. We, of course, as I said before, we license the right to use our patents. We support our products with some level of technology, whether it's software or even physical people on site to help them. What we we haven't, I don't know if this is where you want me to go, but we haven't been the subject of taking of our trade secrets to the best
Yeah.
we know, occasionally, of course, but not a systemic government taking of our property. The way governments, foreign governments, have actually taken our property, so I shouldn't say they haven't, but they have by employing different means, sometimes under the color of law. So most significantly, we've had issues in Korea, in China, in Taiwan, where the governments have basically said, we're going to use our antitrust laws or our competition laws to regulate what you can transfer or how much you can transfer it for. So, for example, we spent 15 months in China being investigated by the NDRC, which was one of the agencies that enforced the anti-monopoly laws there. Now, the NDRC was an agency that existed and predated the anti-monopoly laws, and it was the China price regulator. That's literally what its job was and is, because China, unlike the United States, is a regulated country. And so the NDRC was in the business of regulating prices. When the AML came out, the anti-monopoly law came out, they had a provision in that law very specifically that said, unlike, again, the US, that said they could regulate excessive pricing. And excessive pricing wasn't defined, so presumably the enforcement agency was going to define excessive pricing in any given case. And the NDRC, in its role as a price regulator and now an enforcer of the AML, chose to use that provision to claim that we were charging excessive prices for the royalties that we charged for use of our patents, standard essential patents and non-standard essential patents. And that was the start of a 15-month exchange, which ultimately resulted in a fine of close to $1 billion for us, and a recasting of our licensing program in China for China, but in a way that we ultimately found was acceptable to us. And we were successful in actually turning back several of the concepts or misapprehensions they had about our program. For us, it turned out to ultimately be a good deal because we ended up with a better relationship in China, with what was called a rectification plan, which basically was us abiding by the new regime that we had agreed to. And we modified, as I said, our licensing program to some extent in China, for China. And the result of that was, one of the problems we had before that, and this is kind of not government taking, but company taking. One of the problems we had before that is there are enormous numbers of device makers in China, what we call OEMs. You wouldn't believe how many there are, and we wouldn't know about them unless somehow somebody told us about them or they came knocking on our door. So we had a lot of companies who weren't paying for the intellectual property they were using. Of course, it's patents, and as we all know, there's no way of stopping the use of patents. We publish everything associated with it, and if they want to infringe the patent, they can infringe them. We just have to find them and then take some legal action in a place where there's a rule of law that you can apply. So we didn't know about a lot of the OEMs, the device makers in China. After we finished the resolution with the NDRC, we've subsequently signed up an additional 150 licensees in China, admittedly under the new terms, which were something different from our old, but all in all, it was a net positive for us. The same thing has happened to us. We have a case in Korea, KFTC. They followed China. They fined us close to $1 billion. That one didn't end well, so we're appealing that in the Court of Appeals. We think there's a lot of problems with that, not just substantive, procedural, and that's a wonderful, wonderful case of lack of due process. And If we had time, I would tell you about the process of the hearings in the KFTC. And in Taiwan, they followed suit as well. And it was literally almost a Me Too process. In fact, in Taiwan, there was newspaper articles about legislators asking, when are we going to get our $1 billion? So it was taking under color of law, I guess, is what I would say. But there's no question that, when you deal with different cultures, they do come at things differently than the way we do. And part of it is just understanding their perspective. Now, I had no doubt that there was a large degree of industrial policy being implemented and protectionist activities. But if you're a business that's a global business and you look at the market in China, which is enormous, you have to try to find some ways to compromise. But we never did and never will give access purposely to our proprietary information.
Great. Well, thanks very much. And I know that there's a lot more you could say about that, but you're right. We're getting a little bit short on time. So this is going to be the last question for the panel. I'm going to pose it to Jim here. But if you're ready for questions, please do start to queue up behind the microphones as Jim addresses this last question. We'd be happy to take any questions you have for us. So Jim, what I wanted to do to sort of sum everything up here is take advantage of the fact that you've been in the government, you've been in the corporation, you've been in the private firm, so you've got a wide range of experiences. And you've seen a lot of these issues unfold in your practice and your career. What I think a theme that we're hearing here is there obviously are very serious national security issues that can be presented in the context of investment, doing business, and potentially that can be a tension with what the corporation would most want to do to maximize profit. How do you think the corporations really can balance that tension, or do you even think there really is a tension there? And to the extent that you do, how might the government view the balance of sort of national security policy and industrial policy and making sure that our corporations really have the best ground to compete on?
Well, thanks, Eric. I've been absorbing this as much as possible. Great panel to be on. I wonder if there's not a correlation between the fact that I'm not as smart as these guys and I've never been a professor. So maybe what I'll say is I'm old-fashioned, and I don't really see much tension between the corporate responsibility to maximize shareholder value and being a good corporate citizen, if being a good corporate citizen is helping our country. There are rules that govern that. There are all sorts of obligations that govern that. There's perhaps less discretion than there used to be, and I'll get to that maybe at the end of my time, because I think there's some practical observations I'd make. But I'd say generally there shouldn't be a tension as long as you're careful. So I would look at it a little bit differently. We've talked about some of the very granular obligations, some very important new ones, CFIUS, for example, some great anecdotes from Don and so forth. But drawing back a little bit, looking at things from the corporate perspective, and particularly from a general counsel perspective, you sort of have to look at things like sort of the fiduciary obligations of the board and the management and members of the company. Or also the statutory framework, sort of rules of the road, if you will, statutes and regulations that we've talked about in part here. Certainly contractual obligations, and then even sort of corporate powers, ultra virus doctrine. And I thought I might just sort of touch on each of those briefly as important context for decisions that a general counsel or anybody at the leadership has. I mean, the fiduciary obligations are pretty basic. The duties of care, essentially to make careful, informed decisions, and a duty of loyalty to act on behalf of the corporation and the stockholders by not putting any personal interests in front of those. And I would think analyzing operating, in the interest of national security in that context is not hard to do if you follow the rules. It's pretty generic, but it's important to remember. And that's where I think Randy's comments about inquiries or questions or mandates from various levels of our enormous government, not to mention other countries' government, makes it important to go, as he said, go find an expert. But there is that basic groundwork. There are also statutory obligations. We talked a lot about CFIUS and the recent amendments to that. There are some old statutes that certainly apply in the national security context. The Defense Production Act, which is very broad and has all sorts of powers that are available to the leadership of the country in all different contexts, including national emergencies, some of which have been unending. There are national emergencies that were declared decades ago that still apply for purposes of the Defense Production Act. Also, the Defense Base Act, if you're doing any work for the government overseas. Those are very deep subjects and perhaps a topic for another conversation. Got contractual obligations. If you're a new company, you've got the formative documents of the company. You got you're spun off, and you've got licensing constraints. You've got financing arrangements with affirmative and negative covenants that might be implicated by certain actions that you need to be careful about. You've got joint venture agreements, licenses. Don has talked about those a lot, and certainly contracts with the U.S. government if you have them. And then finally, sort of at the broad level, the ultra-virus doctrine, which essentially is you got to be, if you're going to act on behalf of the company, you got to have power to do it and not step outside of that without certain steps being taken. So I thought that was useful or important to make sure it's laid out that a general counsel has to view these things in a context. And I shouldn't neglect the disclosure obligations, particularly for public companies. Material contracts that reach certain thresholds have to be disclosed unless there are exceptions. And then for the basic securities quarterly and annual filings, trends that should be elevated to the awareness of the shareholder base that may be implicated by doing business with the government. Practical points, if I may.
Yeah.
In the old days, somebody might have walked in to see the CEO and say, look, I need you to do something. And, patriotism being the way it is, they'd go do it. Nowadays, the CEO is likely to come to the general counsel, I would think. The scarier and perhaps more common context, though, is, in my experience, is that whoever's coming in is not going to the CEO. They're going to some organism buried way deep in the company, maybe overseas. And, we sort of train our business people to be sort of like military officers. When in command, take command, go out and make decisions, and ask questions later. Those kinds of things can come and bite you. So the old ways really just don't apply. You want to be asked, and my advice, the first time you get that, is no matter how much you think you know, find somebody outside who's really on top of it. There are all sorts of prudential reasons for that, including CYA, which is a term that we use in the corporate world from time to time. But your obligations to your client to make sure that somebody else who is a true expert in these things is really on top of the latest state of events. And there are all sorts of things besides the jots and tittles of a particular regulation that go into these kinds of decisions. The CFIUS process has, even though it's been substantially enhanced, it's long been a potentially enormous issue that's way beyond, has way more than legal aspects to it. The Dubai Ports case is a good example. I remember from my time in government where, Dubai Ports was wanting to come in and take over the Port of Baltimore, and it probably was resolvable, but it was just the absolute wrong time for that to go anywhere, and it rapidly became, something way beyond what CFIUS required. And there are plenty of other examples of that. Perhaps Don could elaborate on lots of aspects of his own experience recently. So find an expert. Everything's more regulated these days. Randy talked about the government coming in and asking for assistance. There's also when you want to go out and ask the government for assistance. There are different, whole different things that are implicated there. Just an example of non-legal issues. If you're going to be dealing with the bureaucracy, which is notwithstanding our, Constitution that says that the essential decisions have to be made by officers of the United States, which have to be confirmed by the Senate. We see in this issue arising with the new Attorney General, a lot of decisions, way more than any that are visible, get made very low in the bureaucracy. So understanding how things really work, in addition to the way things should work, is so important. You can have an immediate success by sort of plowing through because you're right, or you can have a long-term success if you work it properly. I think probably I'm running out of time.
Great.
So I'll turn it over to you.
Yeah, thank you. Thank you very much. So I see, looks like we have one question already. Your question?
First, thank you all for coming.
If you could just announce your name
Yeah.
and your affiliation, that'd be great.
My name is Miles Lynch. I'm a 2L at University of Pennsylvania Law School.
Great.
I wanted to reframe that last question. You answered that, Mr. Haynes, from a corporate perspective, how to just balance those. But how do you balance, from a public policy perspective, the interests of the nation in policy on innovation versus the national security concerns of other companies or other countries investing in U.S. companies? So my understanding is that there's not enough U.S. VC money to fund all of the startups and companies that are looking for funding. And how do you stop countries like China from just controlling too many things in the United States?
I'll start answering the
Yeah, go
question,
ahead.
but I actually think
Then kick it over to
Tim's
Tim,
probably
yeah.
the expert on
Yeah,
that.
yeah.
I mean, I think the short answer from my standpoint, here I'll turn to the expert, just exactly what I practice, what I preach, but I don't think there's a prohibition on investment. It's just that it needs to be elevated and evaluated, and there are all sorts of mitigation tools that are available to the government so that the government can make a decision. It's just the context of getting the issue up and elevated and making sure that there's a deliberate process to follow. Is that fair?
Yeah, I mean, you sort of raised the big picture policy questions for CFIUS policymakers in Congress and the President. Whenever there's amendments to CFIUS, it always starts with throat-clearing language, or an executive order, throat-clearing language about the importance of welcoming foreign investment as a general proposition in the United States and how it enhances U.S. economic strength and therefore enhances U.S. economic and national security. But, generally expanding concerns about particular types of investments. And I think there's not a prohibition on Chinese investment in the United States right now. There have been very small numbers, very small number of Chinese deals that have been approved by CFIUS during the Trump administration. But I think Chinese investors probably accurately read that the Trump administration was going to be giving an enormous amount of scrutiny Chinese investments, and that itself deterred investment. I've not seen anybody try to assert that massive drop-off in Chinese investment into the U.S. has materially harmed the economy, because the economy's just done very well in that same time period. And foreign investment in the U.S. overall has not dropped. It's just the composition has changed. So for all these issues, when you've got conflict between essentially national security and economic goals, you have to make choices. And given the nature of the U.S.-China relationship and how it is different from the U.S.-Soviet Union relationship, where China is an economic competitor in a way the Soviet Union never was. This is going to be part of that. I mean, battlefield's too strong a term, but you know, very figuratively speaking, this is part of that battlefield, and you know, it's one part of sort of a broader trend in U.S. policymaking that I suspect is not going to change regardless, even if Donald Trump gets beaten next go-round. I don't see any change in this trend.
Thanks very much. Can we go to the mic 2?
John Baker, visiting professor at Georgetown Law. In a way, this follows on that question. And Mr. Haynes was saying there's no conflict between corporate view and national security. And on the other hand, the description of very different so-called market economies in China and elsewhere. Would any of you want to comment on the notion about the theory of free trade? That is, even though there may not be a conflict, many of the corporations are simply criticizing what's going on in the government in this administration as protectionist. And in part, the response from the government is, this is national security. To what extent do you think that internally within corporations, they're beginning to get a view, as I think Mr. Rosenberg has, that is much more complicated than the theory suggests, that you're dealing with different, not only economies, but legal regimes that force companies in one country to do one thing that are not permitted or are permitted in another country? Thank you.
I'll start on the last part of that. Probably about 10 years ago, I made a speech in which I warned about global corporations doing business worldwide having to now be concerned about competition agencies in many more places than when I first started to practice. It used to be you'd think about the DOJ and the FTC and Europe and not much else. Now there are 130 competition agencies around the world. And I remember using the term lowest common denominator, because if you're a company doing business all over the world, you basically can't do different things based on where you are, essentially. I mean, some variations, but not very much. So you've got to basically adjust your practices to make sure you're abiding by the most restrictive provisions, which is a daunting task for companies. Nevertheless, as I said earlier, we're in a global, the idea that there shouldn't be trade or trade should be restricted or we should do something about getting away from a so-called global economy is a dream. I mean, we're in a global economy and we've got to deal with that. So I think what I would like, actually, and again, I'm focused on competition laws, is a bigger focus on due process when we engage with other countries. There's a lot of lip service paid to due process, and I explain this to anybody who would ask me in the government when I was going through the last several years' worth of dealing with several of the countries I talked about. Take Korea, for example. We have a trade agreement with Korea, a bilateral trade agreement called KORUS. And in that trade agreement, there's recent terminology which predated our issues in Korea, which we basically participated in lobbying for, which says that they will provide due process rights to foreign companies to the similar extent they provide them to their own companies. But we even had specific language in there that talked about such as access to the full record if you're being accused of something, ability to cross-examine witnesses. We had none of that when we went through our Korean fair trade episode. But as I've explained now several times, you've got to be careful. It goes back to the cultural point I made before. They agreed to that language, and then their response to me was, "No, you got the record. You've got the full record. That's what you get." And Well, no, you can cross-examine witnesses. It's just the way we do it, which is not on the same day. You can't have any information in advance. The questions have to be pre-arranged and submitted to the. So what I've said to anyone, as I said, who's asked me, and several have in the DOJ. Thank goodness for Macon Delrahim now, who's really pushing the concept. And actually, Roger Alford just 4 days ago made a speech at the College of Europe's Global Competition Law Center in Brussels, talking about due process. And what I said was, it's not just the words. You've got to make sure that you get the concepts down. And so there's got to be some kind of leveling of the playing ground.
Yeah. So we're getting close to the end. I see 2 questions pending. Why don't we just have both of you ask your questions, and then we'll be able to answer them together, or hopefully they're close enough. Go ahead, please.
Good afternoon, JB Tarter with the Defense Intelligence Agency. My question is my own, not representing any government agency. So the assumption that's been provided here is that working with the government is a risk to corporations, either on contract or providing assistance. And for a while, as Mr. Haynes said, the answer was, patriotism, you should help us. But you see corporations publicly saying, we will not work with the U.S. government. Apple's brought that up. Other corporations like Google have said, we will sell our data broadly, but not to the Intel community. So the question on the business side is, what can the U.S. government do to be a positive partner, whereas working with or for the U.S. government is actually a positive for the bottom line in the corporation and not a risk? How can the government make itself a better partner?
I just have to say, this is one time I want to say, we are not a Silicon Valley company. We live in San Diego, near the Coronado, and we work with the government. So.
But you were at Apple.
Let's just get the second question, and then we can answer. Go ahead.
Hi, I'm Ivana Bingochea. I'm a third-year student at Columbia Law School. My question is related. So you mentioned the Carpenter standard, but it is my understanding that despite that ruling, there is a lot of information that the government can subpoena from corporations that have third-party data, like IP addresses and to and from addresses, that are considered business records, and that the standard is like not even probable cause, but something approaching probable cause. Do you think that standard's too low, so I guess in the reverse, or do you think Carpenter was correctly ruled and the government doesn't need warrants for a lot of this data to be disclosed?
You want to take a shot at starting?
So I can start with the second one, and
Yeah.
then and I have some opinions on the first one, but very quickly on the second one. So obviously a subpoena is a standard that's lower than probable cause. A D order is something that approaches probable cause, but it's less than probable cause. So there are plenty of companies that have data. It's their data. It's available by subpoena if it's not otherwise covered by a court case or otherwise. Do I think that that's too low? I think that as a general rule, most of us are far less interesting to the government than we wish we were. And I think that there is plenty of, we go through fits and starts in this, right? The legal regime always has to catch up with technology. It's never ahead of it. And the history is that there's a series of court cases that enrage the enraged legislators one way or the other, and then Congress comes up with a law. And it's happened repeatedly. It's happened periodically since 1968, is in the modern era, that that technology has, that the law has tried to keep up with technology one way or the other. I guess fundamentally my opinion is meaningless about whether the Carpenter was rightly decided or wrongly decided. It's certainly going to make life interesting for my former colleagues back at Verizon and the other companies trying to figure out why 6 days is okay and 7 days is not. It's not very much of a theory, but 7 days was the answer because that was the amount that was taken, and they wanted to reverse. So I think that's just the way that is. On your other question about how can the government be someone that is good for marketing to market with, I think it depends entirely on your customer base. If I don't think that the DIB, the Defense Industrial Base, has any problem being the DIB, and I don't think that I think that they want to be good partners to the government, and I think that I think that if you do not have a consumer base for your customer, you don't have a wide consumer base as your customers, you don't have much to worry about in this lay. It's very difficult to be pressured one way or the other. On the other hand, if you're a consumer company with a lot of data, you're going to have to worry about this problem. I think that Jim's notion of what to do about patriotism is probably the hardest question here. You know, I've been on panels with colleagues, when I was a general counsel, colleagues from Apple and Microsoft and others, and we had very, very markedly different approaches to thinking about whether you're a U.S. company or not. You know, fundamentally, there's a danger of thinking about yourself as a global company. Obviously, you're a global company because you want to reap global benefits. You want to. That's where you go where the market is. You want to get that money in the door, right? And you have to face the issues of law everywhere you go because you're going to be, as a good corporate citizen, you're going to follow the law wherever you are. You're not going to flout the law wherever you are, right? But you know, history hasn't looked too kindly in the longer term on the global U.S. companies who found themselves in the run-up to World War II being big apologists for the big markets they had in Germany. And you know, I think that they should be embarrassed about that. And at a certain point, when push comes to shove, you do have to decide whether you're an American company or not. You do have to decide that I'm going to take certain risks or I'm going to approach things in a certain way because I have duties that go to the heart of being able to be a company somewhere. There's no God-given right to be a company, right? You're a company because there's a rule of law, there's corporation statutes, there's all the other things that make you allowed to be the company. And at a certain point, you got to figure out where you're a company of. And that may alter your approach in these areas that I discussed where the board has to make a decision, where your approach to your technology is significant. And you know, that's just, now listen, most companies don't have to face this problem. This is not a problem for most companies. This is a problem for companies that it gets put into the spotlight when something bad happens and there's a request for information or one of these big deals happen and there's a CFIUS problem. For 99% of the companies in the country, this is an esoteric problem that other people have to deal with and you don't have to deal with.
So Randy, that's a great answer, but maybe more importantly, it's the final answer. I'd like to say thank you to Tim, to Randy, to Don, to Jim, and most important to all of you for coming out. I hope you enjoyed yourselves. And
to Eric, he did a terrific job preparing.
Thank you. I hope you all will come back next year.